We have a quorum. I call to order the meeting of the Bills Committee on Stablecoins Bill. Agenda item number 1, meeting with the administration. Let us invite representatives from the administration to join us.
Hi.
Thank you. Welcome to the meeting. Before the meeting, the administration provided a paper in response to the issues raised at last meeting, CB-1 280/2025-02, as well as 03. Can the administration walk us through these two papers? Afterwards, I will open the floor to questions from members. Thank you, Chairman. Let me take members through our response to the matters raised at last meeting. At last meeting, members referred to Clause 4, Bracket 2 of the Stablecoins Bill. Members mentioned the drafting aspect. Members asked whether we could make it more concise and direct. That is in relation to the power of the monetary authority to specify by notice published in the Gazette under the clause certain matters in Clause 4, Bracket 1. We will review the drafting of Clauses 4, Bracket 1 and 4, Bracket 2 of the bill. If need be, we will move an amendment at the committee stage. Moving on to B regarding Clause 5 of the bill in relation to the wording of meanings of regulated stablecoin activity and related expressions. Member asked whether we would delete significant before public interest in Clause 5, Brackets 5C and Clause 5, Brackets 8. Under Clause 5, Brackets 4, a specification made under this clause is for the purpose of Clause 5, Brackets 1, Brackets 8, Brackets 3 of the bill. We have taken into account the effect of the specification and taken into account the penalties in Clause 8 of the bill for carrying on a regulated stablecoin activity without a license. Our legislative intent is that the matters of public interest that the monetary authority takes into account must be significant. Therefore, we consider it appropriate to keep the word significant before the phrase public interest in Clauses 5, Brackets 5C and Clause 5, Brackets 8 of the bill. The approach proposed in the bill is in line with that under the Payment Systems and Stored Valued Facilities Ordinance. On the last occasion, member asked whether other matters of significant public interest not mentioned in Clause 5, Brackets 8 would be added after Clause 5, Brackets 8, Brackets B in order to reflect more clearly and comprehensively the scope covered under the clause. If other matters of significant public interest that are not covered by Clause 5, Brackets 8 of the bill arise, the MA Monetary Authority would be able to take them into account as provided for in Clause 5, Brackets 5 of the bill, so we don't consider it necessary to expand the list under Clause 5, Brackets 8 of the bill. This is similar to that in the Payment Systems and Stored Value Facilities Ordinance. Member also raised concerns about the wording of meanings of offerings specified stablecoin and related expressions in Clause 6 of the bill, considering whether sufficient before information in Clause 6 brackets 1 will be deleted. Clause 6 brackets 1 of the bill provides that a person, that is person A, will be regarded as offering a specified stablecoin if person A, in the course of business, communicates sufficient information to another person, that is person B, on A, the stablecoin to be offered, and B, the terms on which the stablecoin will be offered, and C, the channels through which the stablecoin will be offered, thereby enabling person B to decide whether to acquire the stablecoin from person A. We consider it appropriate to keep the word sufficient before the word information so as to reasonably confine the scope of offering specified stablecoin on which the restrictions set out in Clause 9 of the bill will apply. We have drawn reference from other international conventions in making this decision. We have drawn reference from the Regulation EU 2023/1114 of the European Parliament and of the Council of the 31st of May 2023, as well as the relevant Market Act in the United Kingdom. Members also asked whether we would provide a supplementary paper in the form of a PowerPoint presentation summarizing the major interpretations and provisions of the bill. We have, as a result, provided a PowerPoint presentation that is CB/1280/2025/03. Will the administration take us through this PowerPoint presentation? We have sent it to members. Thank you. There are many different ways to look at virtual assets, and this is one of the ways. In the world of VA, that is virtual assets, there are different categorizations. One type of VAs is VAs with backing assets. Some examples are tokenized real-world assets, RWA, and stablecoins. Another category is unbacked VAs. In other words, VAs aren't backed by any assets. Some examples are Bitcoin, NFT, and meme coins. From the perspective of regulation, we regulate intermediaries. For instance, to trade these VAs, we regulate the intermediaries in relation to the transactions as a result of such unbacked VAs. Moving on to the next slide. Some examples of tokenized real-world assets are listed below. In the real world, or in the traditional financial world, these are already existent, and then we tokenize them and put them on the blockchain, say green bonds, carbon credits, and gold. Why do we need to put them up to the blockchain? There are some potential benefits. For example, in clearing and transactions, efficiency can be improved. In terms of the keeping of record, transparency can be enhanced. With procedures being streamlined, the cost can be reduced and liquidity can be increased as well. This is what a lot of market players want to see. And this is one of the major developments we have in mind. From the perspective of regulation, in the traditional financial world, we already have these assets. This step is to put them up to the blockchain. And we take into account how these assets are monitored or regulated in the real world. Moving on to the next slide. Going back to VAs with backing asset, that is stablecoins. This slide provides a summary of the landscape of stablecoins in the market. As we can see, in relation to global stablecoin market capitalization, 99% of stablecoins are FRS, fiat reference stablecoins. In other words, they are pegged to official currencies, and top 10 stablecoins are all FRS. So FRS are the most popular in the market. Our draft bill focuses on FRS. Next slide. Apart from official currencies, what other currency are FRS pegged to? As we can see, there are discussions among different international jurisdictions. EU, Singapore, UK, the US, all of them are on the same page. They think VAs should be backed by FRS. This is in line with the legislative intent of the bill. And FRS need to be of high quality and high liquidity. And the next slide concerns the scope of the licensing regime. It provides information about issuance of an FRS in Hong Kong, as well as other relevant information, and I'm not going to read out all the information on the slides. Thank you. I now open the floor for members to ask questions. Members who would like to ask questions, please press the button to request to speak. Questions and answers included 4 minutes. Mr. Rock Chen. Thank you, Chairman. I'd like to ask about B in relation to the clarification of concepts of policies. As we understand, it will take some time, say 1 year, before this bill will come into operation. Before it comes into operation, Schedule 7 provides for a transitional period in which retail investors can continue to transact USDT and DC in the market. They account for 99% of the total stablecoin market. In a scenario, if Schedule 7 expires, and when VOTC ordinance hasn't yet come into operation, there will be a vacuum period, so to speak. Say USDT and DC, are they illegal before this bill comes into operation? If so, we will have to ban such activities in the vacuum period. So how will the administration handle matters in the transitional period? We need to allow seamless transition before this bill comes into operation. And what if there is no license applied for USDT and DC? In other words, retail investors cannot transact such stablecoins. So what if investors still hold these currencies? What should they do? Do they need to sell all these stablecoins before the ordinance comes into operation? Do they have to go to illegal platforms to transact such stablecoins? I'd like to see clarifications from the administration. Thank you.
Deputy Secretary. Thank you, Chair. Can I defer to the HKMA colleague to respond? Thank you. Thank you, Member, for your question. On the transitional arrangement, Mr. Chen referred to an example, i.e., there is a pre-existing issuer in Hong Kong. You quoted two examples. One is Tether, and the other is Circular. Am I correct? I'm talking mainly about DT and DC, which are the largest stable coins around the world. If they don't come forth to apply for a license, what should we do? The first thing, we have to decide whether they are pre-existing issuers first. So if they are, then the transitional arrangement will apply. Well, let's first presume that they are pre-existing issuers. Now, retail users may hold some such stablecoins issued by pre-existing issuers. Even after the ordinance comes into effect, they can sell their stable coins to the intermediaries. But then the intermediaries cannot buy the stable coins on behalf of the users. So that is allowed under the law. No, I would like to follow up. That's exactly what I'm worried about. Based on what the officials said, say if USDT and DC don't apply for a license in Hong Kong, that means the retail investors cannot do any more transactions. Now, well, let's face this reality. Let's look at the development of the industry. USDT and DC are the largest around the world, and we must be concerned about how we should encourage them to do transactions still in Hong Kong and to help with the development of the industry. So we should not just let them not apply for a license and then retail investors cannot transact with them anymore. Then that means stifling our development. First, we have close liaison with the global stablecoin issuers. We have close liaison with the issuers you mentioned. We communicate with them closely, and if they apply for a license, we'll definitely talk to them. Yes, please. Have they expressed their intention to? Well, many issuers told us that they would like to apply for a license, but then they have to meet with our licensing requirements. Say, for example, one of the issuer may have us reserve assets composed of different elements, not just the fiats. So we have to talk to them how to deal with the reserve assets. They have to come forth to apply for a license. They have to meet with the requirements, and that's something that's ongoing. And then we have to look at whether the issuers are pre-existing issues. Only then will the transitional arrangement apply. Yes, we appreciate your question. Thank you. The next one, Mr. Bill Tang. Thank you, Chair. I thank you for compiling such a very brief PowerPoint presentation, which is good. Several weeks ago, people who are very knowledgeable about heritage relics are asking the question about tokenizing some historical relics. So are the stablecoins ordinance bill dealing with this? No, because we are talking about fiat reference to stablecoins. Say if some people in Hong Kong hold historic relics which have good market value, and if they want to tokenize them to promote their circulation and transaction, so how would that be dealt with under our legal framework? Or is there no such legal framework at present? Second question, Mr. Ruckton raised a very good question that inspires me to think about another issue, and there is a possibility here. The scope of your licensing is that the stablecoins issued in Hong Kong and stablecoins issued outside of Hong Kong, but that they claim that they are linked to Hong Kong dollar. Would that be this scenario? Say some people claim that the stablecoins are referenced to Hong dollar, wholly or partly, but then all the use scenarios are outside of Hong Kong. and that they, even if you proactively approach them, they said that they will not come forth to apply for a license. Will, as a result, legal complications arise, and will there be any financial risk involved? Thank you, Deputy Secretary. Well, in previous meetings, when we worked on this bill, one of the focuses is to safeguard the stability of our financial and monetary system. Even if stable coins are not issued in Hong Kong, but these are claimed to be referenced or linked to Hong Kong, we will also be looking at them. At the previous meeting, we have also referred to that. And at the last meeting, we also said in terms of law enforcement, we will seek law enforcement bodies to help us from outside to help us. Now, for other assets to be tokenized, we start from the perspective of protecting investors. If they say that they would do something and offer them to the public for purchase or acquisition, we have to be very careful. Sorry, I don't get it. Are there any laws to deal with the scenario I mentioned? Say if there are historical relics or antique items and they would like to tokenize them, are they covered under existing laws? Is there any protection to the investors in that regard? Let me supplement. Now, tokenization of real assets. What is our regulatory approach? So, well, the tokenization means putting real-world assets on blockchain. So we will look at how the assets are regulated in the real world. And then Francis said, so what kind of scheme is the buyer using to sell the items? So I think we are very mindful about investor protection. So we'll look at how the assets are being regulated in the real world. And the second thing we look at is how they are selling the items. Chairman, please appreciate the fact that Hong Kong is a world-famous market and auction market for selling antiques. So people are already making that kind of inquiry. So it's all right if you don't have the laws to regulate them, but the most important thing is you have to be clear about what you are doing. So can you provide a paper reply, please? Yes. Next one, Mr. Johnny Ng. Thank you. So I would like to follow up on Mr. Ruck Chan's question about the administration's saying that 99% of the stable coins are the two major stable coins, the USDT and USDC. Say if these two companies, for various reasons, cannot get a license in Hong Kong, does it mean that only professional investors can acquire the stable coins through the relevant platforms, and that means the retail investors cannot acquire such stable coins through licensed platforms or regulated platforms? Thank you for your question. 99% of the world's stable coins that I refer to the world scenario, and then you mention a specific example, i.e. the two companies cannot meet the relevant requirements and fail to get a license. Does that mean that retail users cannot acquire the stablecoins? The answer is in the affirmative, because they're not under a regulation. But let me stress, we are liaising closely with the world's major stablecoin companies, not just these two, but many of them. We would talk to them if they would like to get a license. You are referring to a very specific scenario just now. Well, that's very clear. I just want to seek clarification so that they would say publicly, say if these two companies for various reasons fail to get a license, the retail investors, including the SMEs, cannot buy and sell these stable coins on a regulated platform, including the SMEs. Actively market. The stablecoin company may actively market stablecoins to the public. Now, if, say, the tourists come to Hong Kong, stay for a couple of days in Hong Kong. Well, if these people are targeted by the stablecoins issuers, I mean, is this under regulation? Being regulated? Now, when we talk about actively marketing, we are actually referring to an ordinary member of the public, and whether he or she will get to know about the stablecoin through the marketing efforts. So if they come to Hong Kong, they know about this stablecoin, they are considered as members of the public. Now, what about a tourist staying for a few days in Hong Kong? Well, if they are actively marketing the stablecoins to these people, how should we deal with them? Well, in the bill, we talk about members of the public specifically. So tourists don't fall into that category because there is a definition to the members of the public. So let me say something more. Say if there is an event in Hong Kong, activity in Hong Kong, and that activity targets only at the tourists, and all the people in that activity are the tourists. And if the stablecoins are actively marketed to the people there, so will that be covered? Well, that means they fall outside of the definition of members of the public. So they do not fall under the provision relating to actively marketing. Well, this is a question of logic. So does that mean that it's a superfluous? Because, well, they are actively marketing in Hong Kong. Why do you have to specify it is members of the public in Hong Kong? I'm talking about a question of subset. So in the public, that comprises the people living in Hong Kong, tourists, and so on. There is another concept on top of the actively market. There is a concept of offering. Say this is a tourist. He or she knows about these publicity materials. He or she would like to buy or sell stable coins. At that moment, the intermediary has to ascertain whether which country the person comes from, whether the country allows the person to do such activity. I have to engage in the KYC, know your customer process. So that means that tourists in Hong Kong should not do something that he or her her country does not allow he or she to do. Well, Mr. Raktan, may I follow up on my earlier question, also Mr. Johnny Ng's question? We understand thoroughly the concept. Let me make a suggestion here, because in fact, over 99% of the market are taken up by USDT and USDC, but the others are very, very small issuers. So if you want to develop the country, you have to be very mindful about what USDT and USDC are doing. So if they come to apply for a license, they have to meet with the legal requirement. That's for sure. But what we are concerned is that we have to talk closely with them. We have to proactively reach out to them to ask them to come forth to apply. Well, omitting the Hong Kong market doesn't make a lot of difference to them. But for us, we're looking at this bill. We would like to protect the investors. We would like to do the best regulatory job. We would like to drive the development of the industry as well. So I hope that they can come. Now, if when you talk to them, you know about certain provisions which they are concerned about, or even if there is a provision which stifles their intention to come forth to apply for a license, then we can act quickly. We would like to revise the provision so that they would come forth. We would like the retail investors to continue buying their stable coins, or else our development of our industry will be greatly undermined.
Thank you, Mr. Rock-Chan. Mr. Rock-Chan and Dr. Johnny Ng's questions are very good. I'd like the administration to follow up on their questions and suggestions. Please provide a written response before the next meeting. Thank you, Chairman. Just now, Ernest answered members' questions. From the perspective of protecting investors, we also need to promote market liquidity, we need to strike a balance. We have close liaison with the two major companies regularly. As Mr. Rock Chen said, in case of any difficulties, we'll definitely see how we can further provide assistance. Thank you. At last meeting, we already started clause-by-clause scrutiny, and we finished with scrutinizing Part 1 of the bill. Could the administration start from Part 2? Can you take us through the provisions? Thank you. We'll start from Part 2, Regulation of Activities Involving Specified Stablecoins. There are 5 subdivisions. There are 5 divisions. 1. Restrictions on activities involving specified stablecoins. Clause 8. Aside from licensees, a person must not carry on a regulated stablecoin activity or hold the personnel as carrying out a regulated stablecoin activity. Otherwise, one may be held liable to an offense. Clause 8(3) sets out the penalties. Clause 9. Offense related to offering specified stablecoins. Permitted offerer in Clause 9(5) or (13)(1a) or 13(3a). A person must not offer a specified stablecoin or hold the personnel as offering a specified stablecoin. Otherwise, one is liable to an offense. And the provisions provide detailed information in this regard. In brackets 2 of Clause 9, brackets A, it sets out the first situation. Both of the following situations are fulfilled. 1. The person is a permitted offerer. And please refer to brackets 5 in relation to the definition for a permitted offerer. Going back to brackets 2, the issue of the specified stablecoin is authorized by the license. Well, excuse me, I have a question. In relation to the word authorize, in subsequent provisions that touch upon the offense and the penalty, I'd like to know if there is any legal document or official legal document about authorization. In the future, if an issuer claims that it is authorized, is there any provision providing for official authorization? Will it cover the licenses granted by the Monetary Authority, MA? Thank you. Please continue. B. It sets out the second situation. All of the following situations are fulfilled. 1. The person is a permitted offerer. And please refer to the definition for permitted offerer in brackets 5. And just now, we touched upon Section 8. That is, the issue of the specified stablecoin is not prohibited by Section 8. Bracket 3. The person to whom the specified stablecoin is offered is a person or a person of a class specified under subsection bracket 3. The Financial Secretary may, by notice published in the Gazette, specify a person or a class of persons for the purposes of subsection brackets 2, brackets B, brackets 3. And that is in line with our legislative intent. Moving on to C. Both of the following situations are fulfilled. 1. The specified stablecoin is to be issued by the person. 2. The person is a person or a person of a class exempted under Section 13, brackets 1, brackets A in relation to the issue of the specified stablecoin. D. The person is a person or a person of a class exempted under Section 13, brackets 3, brackets A in relation to the offering of the specified stablecoin. These provisions aim at providing flexibility. Just now I mentioned brackets 9, brackets 5 in relation to the definition for permitted offerer. That is 1. Licensee, 2. A corporation as defined by Section 1 of Part 2 of the Schedule 1 to the Anti-Money Laundering and Counter-Terrorist Financing Ordinance that is granted a license under Section 53 ZRK of the Ordinance to provide a VA service. C. A licensed corporation as defined by Section 1 of Part 1 of Schedule 1 to the Securities and Futures Ordinance that is licensed for a Type 1 regulated activity under Section 116 of the SFO, or D. An authorized institution. Moving on to Clause 10. Offense related to advertising regulated stablecoin activity and advertising offering of specified stablecoin. A person commits an offense if someone who is not a license holder publishes or has in the subject person's possession for the purpose of publication or make any advertisement is liable to an offense. Brackets 4 provides some exceptions. A person doesn't commit an offense under subsection 1 or 2 merely because the person publishes or has in the person's possession for the purpose of publication an advertisement or document. If A. The advertisement or document was so published or possessed for the purpose of publication in the ordinary course of a business, the principal purpose of which was receiving and publishing materials provided by others. Brackets 5. A person doesn't commit an offense under subsection 1 or 2 merely because the person publishes by way of live broadcast or has in the person's possession for the purpose of publication by way of live broadcast. Mr. Bill Tang. Thank you, Chairman. What does advertisement mean? Of course, if one conducts business, then there is no problem. Is there any standard format in relation to advertisements? And what if a stablecoin is unlicensed or is not registered? If one draws reference from international experience, or if the stablecoin is registered in an overseas jurisdiction, and then the advertisements in that jurisdiction are forwarded to Hong Kong, advertisement includes every form of advertising, whether made orally or produced mechanically, electronically, optically, manually, or by any other means. That is the definition for advertisement. We don't want someone to offer to somebody to transact the stablecoins. If someone uses an advertisement in an overseas jurisdiction to induce somebody else to buy a stablecoin, such an offer or provision of information may be caught under our regulation scope. So what if it takes place from the perspective of academic exchange or a seminar? So how will you handle these cases? Just now Timothy was reading out subsection 4. Well, it depends whether in the ordinary course of business someone has to forward such information. If someone isn't responsible for forwarding such information and all of a sudden someone posts such information online, then he or she may be caught under the regulatory scope. Mr. Robert Lee. My concern is similar to the previous members. After all, according to the definition of advertisement, some are physical advertisements. On public transport or in other places, we see conspicuous advertisements. Some KOLs share their views or analyses online. In relevant legislation in relation to securities and futures, there are some exceptions. State news reporters, there are exceptions. But when the bill comes into operation, how can it protect the public given the fact that these may be something new in the market? Those transact businesses with license are subject to regulation. However, some online KOLs aren't subject to regulation. So is the definition for advertisement providing sufficient regulation or providing sufficient protection? If someone doesn't have to obtain a license and someone can say whatever he or she wants online, is there any regulation or protection offered? In clause 10 brackets 1b, well, it mentions to the subject person's knowledge the advertised person is not a person or a person of a class exempted under section 13 brackets 1 brackets b in relation to the regulated stablecoin activity. In relation to the definition of publish, there is a definition. Let's refer to brackets 8. In G, it sets out clearly by way of social media. Member refer to KOLs. If a KOL publishes incorrect information, he or she will be caught by such provisions as well. Dr. Johnny Ng. Thank you, Chairman. I am concerned about advertisement. In the world of virtual assets, airdrop is a common way, and airdrop is free. How does this bill regulate airdrop? Francis, thank you. Likewise, we try to allow flexibility in this regard, but technologies do evolve. In brackets H, under the definition for publish, by an information system or other electronic device. We believe this definition will cover what you have just now mentioned. Any follow-up? No, thank you.
Yeah.
Dr. So Chang Wing. Chair. Part 2. Division 1. The headings said that a person. And then there is the definition of subject person. So what is the definition of subject person? Specifically, what does it refer to? How does it apply? And then in the definition, in this division, there is no definition of subject person. Can you, I learned more? Yes, thank you, Chair. A subject person, that is a tag definition technique. So we use a labeling method. We say it is a subject person. It's like party A and party B, or person A, person B. Why do we use subject person? Because under clause 10, there are many different types of persons. So if there is a subject person, advertised person, so we use these subject persons expressions and advertised persons to differentiate between the two. So when we refer to subject person, that refers to the person referred to in clause 10 bracket 1. A person should cover any people. I really don't understand. Because in the definition part, there is no definition on the subject person. Now in the previous sections, we refer to person A and person B. That makes it easier for you to understand. But then, using that excessively will also confuse people. So a person, subject person, means a person who takes out the advertisement. There is no need for a separate definition for that term. Okay, please move on to clause 11. 11. Offenses involving fraud and deception in relation to specified stable transaction. Bracket 1. A person commits an offense if the person directly or indirectly in a transaction involving a specified stable coin employs a device, scheme, or artifice with intent to defraud or deceive, or engage in an act, practice, or course of business that is fraudulent or deceptive, would operate as a fraud or deception. Bracket 2, that is in relation to the penalty of the offenses. Clause 12. Offenses for inducing others. Well, Mr. Ronick Chan. The heading of clause 12. Is there a typo there? In Chinese, 有使他人取得等指明認定by的罪行. English, offense for inducing others to acquire, etc. Specified stable coin. Draftsman, please. Yes. 等 in Chinese is equivalent to etc. in the English rendition. According to Cap 1 of the Hong Kong law, the heading is not legally effective or does not have any legal power. If we include acquire, dispose of, subscribe, etc. in the headings, then that would be too cumbersome. So we would just use acquire, etc. in the English rendition, and then Chinese 取得等. I think we should make the Chinese rendition comprehensible to an average person. Now, we used to have such drafting approach, but I think we should make sure that the drafting is comprehensible to the general public. So we should not just stick to the tradition. I suggest that it be amended to make it more easily comprehensible. So the law draftsman, can you look at that? Well, one of the approaches is to list out all the terms there. But then listing all the expressions may not be the best approach. Let me try to change the way the heading was drafted. Yes, okay, please move on to Clause 12. Well, in relation to the following situations, we would set out the offenses, and that is offer or enter into an agreement or acquire, dispose of, subscribe for, or underwrite a specified stablecoin, and but in doing that, use a fraudulent misrepresentation or reckless misrepresentation. And then we list out in detail what we mean by fraudulent misrepresentation and reckless misrepresentation. Clause 13. Empowering the monetary authority to grant exemption so that such people would be exempted from the regulation under sections 8, 9, and 10. Yes. Clause 13, I have a question. That is granting the monetary authority the power, the exemption to people who would like to engage in regulated stablecoin activity. Can you elaborate on this section? How to make an application? What are the exemption procedures? Can you give more details? Secondly, on the policy level, we have discussed about the SVF. These are not exempted. But then in the sandbox, there are already 2 SVF operators there. Does that mean that SVFs are exempted because in the sandbox they're already exempted? Thank you. Thank you, Chair, for your question. 2 questions there. First, the procedures for exemption is very simple. They come to talk to us, and that is the as simple as that. And then for stored value facility SVF, Clause 13 is not to cover SVFs because for 13(2), it says that the monetary authority can only exempt operators which will not constitute financial risks. But then SVFs are under a regulation because they can pose financial risks. So SVFs are not covered under this clause. Well, if they are to be covered, then they have to be included in the permitted offers list. But last time, we are already saying that we are actively considering adopting that approach. And after detailed contemplation, we would talk to you, share with you our latest thinking. We are also talking to many SVFs operators in the market. We're actively considering that point. Thank you. Please continue. No further question then. I will move on to Clause 14. Division 2 about licensing. And that is licensing for engaging in regulated stablecoin activity. There are 5 subdivisions. In coming up with the licensing system, we have taken reference from other ordinance like the PSSVFO and also the AMLO. Section Clause 14, application for license. And the procedures are set out here. An application can be made by a company or an authorized institution incorporated outside Hong Kong. Clause 15, the monetary authority may determine an application for a license based on certain considerations, and the considerations are listed out in bracket 2. The monetary authority may grant a license with or without conditions when granting a license. And then, in accordance with bracket 3, the MA must be satisfied that the minimum criteria applicable would be fulfilled, and that are set out in Schedule 2 of the bill. And then Clause 16, validity of license. In the bill, the MA issue a license, and it will remain in force until it is revoked under other sections. Clause 17. The monetary authority is empowered to attach conditions that it thinks fit. Section 2 lists out all the relevant conditions, setting out the business activities of the licensee under the license, or the licensee. There were additional requirements imposed on the reserve assets, and also additional financial resources are required. And clauses 18 and 19 are about the procedural requirements for attaching licenses and for amending existing conditions. In short, when the MA decides whether to attach license or amend conditions, he must give a written notice to the applicant, and then 14 days will be allowed for the licensee or the applicant to make a written representation. And after taking into consideration the written representation, the MA must notify the licensee in writing whether the conditions will still be attached. Clause 20. The MA may cancel a condition attached to a license. Clause 21. The MA must maintain a register of licensees, and details of the register are set out here. Bracket 7 says that the MA must make the register available for inspection by the public in the form and manner deemed appropriate. Clause 22. The licensee must pay to the MA an amount specified in Schedule 3 and an annual fee of $113,020. And Clause 23, the licensee must ensure that the license number of its license stated on any advertising materials, consumer-facing interface, and so on. Clause 24 requires that a licensee must ensure that the minimum criteria applicable in relation to the licensee are fulfilled during the entire licensing period. Clause 25, if the licensee thinks it's likely to become unable to meet its obligations, is insolvent, or is about to suspend payment, it must report the matter to the MA. Clause 26 says that the licensee must report a change of address to the MA. Mr. Tan Yue-Heng. Thank you, Chair. We are talking about licensing. A company must have a business premise, a principal business presence. Co-sharing or co-location office space is very popular. Many companies are using co-working space now. Now, if they are using co-working space, are these premises being duly recognized by the administration? Well, under a requirement, it must have a physical presence or business premise in Hong Kong. We don't specify that it must be in, say, a Grade A or Grade B office building. Well, objective is that if anything untoward happens, there is a way that we can contact the licensee. So there is no specific requirement on the kind of premises the office has to be situated. And stablecoins are an important component of our financial landscape. So we have a minimum capital requirement, and that is $25 million. So we must ensure that a trustable enterprise is given a license. Any follow-up, Mr. Tang?
No, Thank you. Next member, Mr. Bill Tang. I'd like to ask about Clause 25. I think it's very important, and I do think we should discuss this clause further. When a license holder takes up a lot of advertisements or making other people believe that the stablecoin might increase in value, hence their investment in the stablecoin. And then when the license holder claims that he or she doesn't have the ability to meet the obligations and folds the business, what happens? Clause 25, duty to report inability to meet obligations. Does it mean that one can simply go away, surrender like that? What is the legislative intent of this clause, Clause 25? Well, likely to become unable to meet its obligations. It's quite vague. Do you have any standards to go by? Say, a lot of legal proceedings ongoing. Can you be more specific? Are there any criteria? Is there any duty for that person to report the matter to the MA as soon as practicable? It's not settled here, it seems to me. So what if one does have this situation, but then one doesn't report the matter to the MA as soon as practicable? What happens then? I'd like to hear more about the details of this clause. Thank you. Clause 25 is a requirement. If one feels that one doesn't have the ability to meet the obligations, one will have to report the matter. But we don't only rely on this clause to take action. We require license holders to submit information, and at the next meeting, Clause 111, the MA does have other regulatory requirements. For example, the MA can examine books and accounts and so on. In Clause 25, we mean in daily inspections when we identify such situations. If the license holder feels that he or she is unable to meet the obligations, he or she will have to make the report as soon as possible, failing which there will be a penalty. For daily inspections, I will defer to the MA. Let me supplement on the legislative intent of Clause 25. Members just now mentioned what constitutes inability to meet obligations. Let's go back to Clause 2 interpretation. Well, let's go back to 2 brackets 5. The cessation of ordinary course of business, or when one is unable to pay off the debt. In our inspection or regulation over the license holders have the responsibility to fulfill this responsibility. When one fails to meet these obligations, one commits an offense. We keep a close watch on the license holders. We check whether they are financially sound or not. Say someone may lack cash liquidity to meet the obligations. We adopt the perspective of protecting users. So we put in place this requirement to report inability to meet obligations. Maybe Ms. Carmen Can will go first. Afterwards, Mr. Bill Tang will supplement in another round. Thank you. I'd like to ask about Clause 25 and Clause 24. I'd like to look at these two clauses together. They concern the responsibility of the license holders, one fulfilling minimum criteria. I understand this. Against a backdrop of clauses 24 and 25, a total of 3 sandboxes we have. Do we have a reasonable expectation now that some projects are in the stage of sandboxes? When this bill comes into operation, they will become license holders as well. Do they fulfill all of your requirements? I'd like to know more about this. In Clause 25, the Chinese version is as soon as practicable after it appears to a licensee that it is likely to become unable to meet its obligations, is insolvent, or is about to suspend payment. It must
to a licensee that it is likely to become unable，即係嗰個係咪一個主觀嘅？
Is that subjective? Say if one doesn't feel or doesn't think, does one still need to report the matter to the MA? I'd like to know whether this is common. Do you have any previous case, any precedent? You may give us more information to give us peace of mind. Thank you, Ms. Carmen Can. I'll take the question about sandboxes regarding participating institutions of sandboxes. What happens when the sandbox projects are completed? Well, on the one hand, we want to enhance communication. We want to tell them our concepts of regulation. Then they can also tell us what they find unreasonable. That's a concept of sandboxes. For participating institutions of sandboxes, they will have to provide or submit a formal application. In the course of sandboxes, we'll have a better idea of these institutions. Well, we may, because we have a better idea of each other, we may continue to collaborate or we may part ways. So when they submit a formal application, we'll remind the participants. This is clear. Sandboxes mean they are pilot projects. So when they identify certain difficulties, or if they find that the result isn't what they expected, they may not file an application. In the context of sandboxes, the affected groups are, so to speak, controllable, and the public needs to understand. Sandbox projects won't cause any impact on the public in general. We'll adjust our regulatory approach. Yes, that's right. Well, MA, can you respond to Ms. Carmen Can in relation to the phrase is likely to? Well, it appears means legal element. That is when one feels. When one feels so, then one will do so. The legal element is that it appears to a licensee as such, and that is the policy intent. Ms. Carmen Can, well, I don't think it answers my questions. Well, we've drawn reference from the banking ordinance as well as the payment systems and stored value facilities ordinance. Similar practice is in place. As the DOJ said, this is actually a subjective judgment. If one feels that one cannot fulfill or to meet the obligations, then one will have to make a report. In Schedule 4, it sets out the grounds for revocation of licenses. In Schedule 4, Clause 4, the licensee is unable to meet its obligations or the licensee suspends the payment. These are the grounds on which a license may be revoked. This is not a subjective judgment. These are based on facts. These are factual. So if a licensee fails to report the inability to meet the obligations, it is not true that he or she doesn't have any responsibility. Ms. Carmen Can, well, I'd like to know how the Hong Kong MA will continue with the continuous regulation monitoring. If one doesn't subjectively feel so, we need to be convinced that the Hong Kong MA plays the role of continuous monitoring of the situation. That is because the Hong Kong MA will have to take the initiative to do so when they identify such situations. Well, there are two parts to monitoring or regulation. One, under the regulatory framework, the licensee needs to, on a regular basis, provide information such as financial position as well as other information. And when incidents happen, then the licensees will have to make a report to us. Apart from obtaining information from the licensees, we conduct surveillance in the market as well. Especially when it comes to stablecoins, these are very highly transparent activities, and we have access to a lot of information on the blockchain. We'll continue to enhance our market surveillance framework. That's how we tap the pulse of the market. For similar activities, we also conduct regulation as well as monitoring. All these combined will lead to the conviction that what commercial acts or actions we will need to take. Thank you for recognizing this. After the licensee obtains the license from the banks, the Hong Kong MA will have to keep a close watch on the market, and you will have to conduct regulatory activities in the market. These are not areas in which we are versed. Thank you. Mr. Bill Tang. When the Hong Kong MA thinks that a licensee carries great risks, whereas the licensee himself or herself is very optimistic, what happens? That is, in the opinion of the MA, it appears that the licensee is likely to become unable to meet its obligations. So what will the Hong Kong MA do after this bill comes into operation? Thank you. Under Clause 25, it's about when the licensee feels that it is likely to become unable to meet its obligations. Schedule 4 is about factual basis. We'll have to meet the requirements set out under Schedule 4. If the licensee feels that he or she is doing very well, we'll still have to abide by the criteria listed under Schedule 4. When the requirements are met, then we can take action. Well, that leads to another question. The Hong Kong MA will have to rely on Schedule 4 to revoke the license when the licensee feels that he or she is doing very well. So will criminal offenses be taken out against the licensee? Well, Clause 25 is about when the licensee feels that he or she is likely to become unable to meet its obligations. If licensee feels that he or she is doing quite well, then Clause 25 doesn't apply. Will there be a loophole? Say when the licensee feels in his or her heart that he or she is unable to do so, or is likely to become unable to do so. Well, the revocation of licenses is a serious decision. I'm not sure if that will impose a criminal responsibility on the licensee. That is, when the licensee feels that he or she is unable to do so, but then he or she will drag on until investors suffer a lot of losses. And when the MA revokes licenses, will Clause 25 still apply? The licensee may still think that he or she is doing quite well. Then, in this case, Clause 25 doesn't apply because it's all about the licensee feeling that he or she is likely to become unable to meet the obligations. Are there any other criminal provisions or offenses that will apply?
Yes, that's very true. Well, in the earlier reply to Ms. Carmen Khan, we said that we would have a regular supervisory framework, would obtain a lot of information from them, where we'll closely monitor the situation of the market to ascertain whether this licensee is doing properly. And then if we gather enough facts, we may act in accordance with Schedule 4. Do you get my point? Because there is a criminal element in Section 25. And in Schedule 4, you just revoke the license. You would not hold them criminally liable. But then there is a criminal offense mentioned in Clause 25. But if they said all along they're faring well, then you would not be able to catch them. Now, what Mr. Bill Tang said is that if the licensee thinks that they think they're doing well, but in fact they are not doing well. So were there any ways adopted by the administration to protect the investors against losses resulting from their belief that they are doing well? Okay, I agree that every licensee believes that they're doing okay or properly. But then, if we spot anything irregular, we may attach additional licensing conditions to restrict the licensee's activities. And then, at the end of the day, if we find that they are really unable to meet their obligations, we would resort to Schedule 4 as a last resort, and we'll collect facts and decide on the way forward. Well, there are many things that we can do from a supervisory perspective, but the revocation of license will be only the last resort. Thank you. Mr. Tan Yue-heng. Thank you, Chair. These several clauses talk about the changes in the circumstances of the licensees, and they have to report to the monetary authority the same information. There are deadlines, say within 10 days, 14 days. But then in some other situations, you said that as soon as practicable or as soon as possible is in clauses 26 and 27. Well, but then clauses 26 and 27 are also about specific circumstances. Why do you say it's as soon as possible instead of specifying a period in which they should make the report? Ernest or the Deputy Secretary? When we worked on 25, we say that as soon as practicable, well, we want them to do so as soon as possible. The MA colleague also said that when we drafted Section 25, we also drew reference from the banking ordinance and similar ordinances. So we use the same expression as those. When it comes to reporting the change of address, it's more a administrative matter. And then in Clause 25, as Mr. Bill Tang rightly pointed out, it's a more a graver situation. So that's why we said that the report should be made as soon as practicable. Any follow-up? No? Ms. Carmen Khan. After our discussions just now, including what Mr. Bill Tang said, Schedule 4 is about revocation of license. And then in Clause 25, we're talking about very serious situations which have had great impact on the members of the public and the investors and the stablecoin holders. Well, the licensee is about to suspend payment, if we just count on the licensees, feeling that it appears that this will be so, and if we also look at the section 2, the license will only commit an offense if he doesn't have a reasonable excuse. I think both the subjective and objective elements should be put in bracket 1. Say for a reasonable man, if he is in that kind of situation, he would would report. And that would constitute the reasonable excuse, because the criminal offense here is serious, and this is different from Schedule 4. If I can refer members to Schedule 4, if you like to look at it, please do so. But these are really major obligations there. So if you just include the subjective element, I think it doesn't suffice. It's different from the PVSVFO. We can't draw too much reference from the PSSVFO because the losses to be incurred by the investors in that other ordinance may be relatively limited. Well, we haven't gone to that section, but we said that MA can exercise certain powers under certain scenarios in Section 77, which says that if the MA thinks that the licensee believes that it is unable to meet its obligations, and then it can invoke the power in clauses 78 and 78 to appoint a person to manage the matters of the licensee. So sections or clause 77 is one of the approaches that we can provide safeguards. Thank you. So please revisit this provision. You mentioned about 77 being of some help. That's related to the continuing supervision on the part of the MA. But I think, well, changes may happen very rapidly, and the financial conditions may also change very rapidly. We know that they do have reserve asset. They do have the paid up capital of $25 million, but then changes may come very fast. So can we also add in an objective element to the provision? Or else the criminal offense provision may not be deterrent enough. Many members have different concerns and questions on Clause 25. So can the administration respond to the members' concern on Clause 25? Can you add in both the subjective and objective elements to the clause so that the licensees are made very clear about their obligations? Yes, that can be done. Thank you. Okay, let's move on to 27 then, Clause 27. The licensee must report to major changes in circumstances. Subsection 1 quote talks about specific examples. A is about the licensee's ongoing fulfillment of any of the minimum criteria applicable. B is about the licensee's ongoing compliance with any of the conditions attached to its license. And then subsection C, the licensee's carrying on of any of its business activities under its license. If they have a material change in the circumstances mentioned, it must report to the MA as soon as possible. Clause 28, the MA is empowered in accordance with the Schedule 4 to revoke the license of a licensee. Before it does so, it must give a written notice and its intention and the ground for the revocation, and also give a period for the licensee to make written representation. And clause 29 relates to the circumstance of a licensee. A license granted to a licensee is revoked if the licensee is wound up, deregistered, or struck off of the company's register. Clause 30, effect of revocation. The former licensee must comply with the direction issued by the MA. Clause 31 is about the licensee under the revocation of license. The MA may give direction on how to dispose of the assets. 1A is that the MA can attach the direction any condition and may also amend or revoke the direction and attach new conditions. Clause 32 empowers the MA to, in urgent circumstances, temporarily suspend a license for not more than 14 days. And clause 33, the MA can, based on Schedule 4, revoke a license for no more than 6 months. Ms. Carmen Khan, thank you. Chair, I'd like to ask a question about a license. You talk about certain procedures. You will notify the licensee to, if a condition under Schedule 4 arises. Well, let's take a look at Schedule 4, which contains the grounds for revocation of license. And the licensee is also given a chance to make written representation. It has a chance to say that what you find out is not true. Well, I suggest we took a look at Schedule 4. And then what about the stablecoin holders? Do they get the money back from the reserve? The bill sounds theoretical now. Will the reserve be enough to pay back the stablecoin issuers? So, Deputy Secretary, can we take a look and explain the Schedule 4C 3588? Okay, can I defer to the MA colleague to talk about how to handle the reserve asset when a problem arises? How will the money be given back to the stablecoin holders? Thank you, Ms. Khan, for your question. First, about how to dispose of the reserve asset. In our ongoing supervisory framework, we will require the issuers to tell us frequently and regularly the situation of the reserve asset. One important point is that the reserve asset must be segregated from the issuer's normal asset. They can do so through a trust or set up a vehicle to store the user's fiat assets. When the user becomes insolvent or runs into financial difficulties, the fiat reserve asset in the trust will not be affected. If this does happen, like what Ms. Carmen Khan said, that would be a orderly wind down. So I'll pause here. Any follow-up, Ms. Carmen Khan? Can you tell us more about what is a reserve asset like? So if we issue a $100 stable coins, what is the amount of reserved asset required? $100, but then, well, the price or the cost may fluctuate. How can they report to you through what kind of mechanism? Well, they are required to put it in the trust, but how would you verify the fact they will continue to hold this amount constantly? This is linked to a fiat, so stable coins should give greater confidence to investors compared to the virtual assets not backed by assets. But then we don't want to give a misconception on the definition of stablecoins. But then the devil's in the details. So can you tell us more about how you will regulate?
嘅。第一方面，
Thank you. For V8 reserved assets, at least 1-to-1. For V8 as backing reserved assets, they may fluctuate, so it depends on what type of V8 reserved assets are to be used. And we also take into account the historical fluctuations, say per 100, then one may have to put 101 or 102. There may be monthly or quarterly disclosure to the public, telling the public about the circulation of stablecoins as well as the fiat disclosure. The public will then know that the issuer of the stablecoins is fully backed or not. So on the one hand, we take into account the fiat reserve assets fluctuations, and there should also be a regular disclosure to the public on the other hand. Any supplements? Ms. Carmen Can? Is the disclosure made on your website or the website of the issuer? That is my first question. How will the public know? The second question in relation to the arrangement for trusts. Will we see more details about such trust in subsequent provisions? Thank you for disclosure. It's on the issuer's website. Say if the public disclosure is a quarterly one, we require more frequent private disclosures. Regarding your second question about trusts, will it be provided for under your bill? Yes, it will, and in the supervisory guide, we will also detail it. These arrangements are not exclusive to just stablecoins. For Alipay Autopass, that is for other payment systems and stored value facilities, this also applies. Can the administration take us through Schedule 4? Thank you. It sets out the grounds for revocation of licenses. From one, we'll start from 1. One licensee doesn't fulfill one or more of the minimum criteria applicable in relation to the licensee. 2. The licensee proposes to enter into or has entered into a composition or scheme of arrangement with its creditors, or is being wound up or otherwise dissolved. 2. The licensee has informed the MA that A. It is likely to become unable to meet its obligations, B. It is insolvent, C. It is about to suspend payment, or D. It is about to suspend any of its business activities under its license. 4. The licensee is unable to meet its obligations, suspends payment, suspends any of its business activities under its license. In 6, the licensee has provided the MA with any information that is false, misleading, or inaccurate in a material particular. 7. The licensee has contravened the condition of the license. 8. The licensee has ceased to carry on any of its business activities under its license. 9. The licensee has failed to pay a license fee in compliance with Section 22. 10. A person has become a controller of the licensee despite a notice under Section 38(2)(b) being in effect in relation to the person. 11. A person continues to be a controller of the licensee. Well, can I chip in? Excuse me. You are simply reading out all the provisions under Schedule 4. For 38, what happens. In clause 38, when one becomes a controller, in clause 38 brackets 2 brackets B, on receiving an application under subsection 1, the monetary authority may, within the period specified in subsection 4, subject to section 41, by written notice, object to the person becoming such a controller. Excuse me, Chairman, I'd like to see clarifications from the administration. We need to be clear on this. Is this correct? Yes, let's move on to clause 39. 39 brackets 3 brackets B or clause 42. They are all about whether the controller is approved by the MA. Clause 12. The licensee is in contravention of section 53, 58, or 66. It's about the appointment of the chief executive and alternate chief executive. And that will lead to the revocation of licenses if one is in breach of clause 53. 13. The interests of the holders or potential holders of any specified stablecoins connected with the license of the licensee are threatened in any manner by the licensee continuing to be licensed. 14. The licensee engages in a business practice that would be likely to affect the interests of Hong Kong as an international financial center. 15. The licensee has failed to pay a pecuniary penalty required under Section 131 brackets 2A within the period mentioned in Section 133 brackets 1. 16. The licensee makes a written request to the MA to revoke the license and the interests of the holders of any specified stablecoins issued by the licensee. Yes, what I read out just now are the grounds for revoking license. Alright, let's go back to clause by clause scrutiny. Ms. Carmen Khan, well, I'd like to ask about 16. Can you tell us more? It is a requirement imposed on the MA. It's not just the, it's not like when an application is made to revoke the licensee, then the Hong Kong MA will revoke the license accordingly. When the licensee makes an application, the Hong Kong MA needs to be a gatekeeper. Which official will take this question? Thank you. In 16, when the licensee wants to give the license back to the MA, one will have to make a written request. The MA will have to consider whether the interests of the stablecoin holder will be protected appropriately. So you have the responsibility for making sure the interests and rights of stablecoin holders will be protected before you will proceed with the revocation of the licenses. Is that correct? Yes, that is correct. When the licensee makes this written request, it doesn't mean the license will be revoked instantly. We have the wind down as mentioned by the Hong Kong MA. We need to make sure the stablecoin holders are sufficiently protected. Then we will proceed with the procedures to revoke licenses. Thank you. Dr. Johnny Ng. Well, am I coming through? Am I coming through? In 131, the MA may impose sanctions on regulated person. The penalty may be in the amount of $10 million. or 3 times the amount of profit, gain, or loss avoided by the person as a result of the contravention. If the licensee doesn't pay the penalty, that will lead to another ground for the revocation of the license. Thank you. I'd like to make a point. In relation to sanction, that is part 6. The official referred to clause 131. In the banking ordinance, the MA isn't empowered as many means. However, against the backdrop of stablecoins, I do think we need to have an enhanced version. We shouldn't just rely on the banking ordinance. The MA should be given more powers. And all these may lead to amendments of the banking ordinance. Thank you. No supplement? No. Next member, Dr. Johnny Ng. Thank you. I'd like to talk about 14. The licensee engages in a business practice that would be likely to affect the interests of Hong Kong as an international financial center. Do you have any examples to give us? What instances will affect the interests of Hong Kong as an international financial center? Chris? Well, we aren't in a position to detail all the scenarios. For malpractices, we have drawn reference from the banking ordinance as well as in the PSSVO. Can you tell us one or two cases that lead to the revocation of licenses? Well, as I understand, the MA hasn't revoked any license on these grounds. Well, I couldn't envisage any scenario either. Well, I agree with Chris. Just an example, we aren't encouraging such acts at all. For some business models, they may involve money laundering, and that will affect the interests of Hong Kong as an international financial center. This is an example that we can come up with, but we aren't encouraging such acts. Alright, let's continue with the scrutiny of Clause 34, right? Clause 34, effect of suspension. Once the license is suspended, the licensee will have to comply with the directions from the MA. In Bracket 1, during the period when the license is suspended, the licensee must not and must cease to carry on its business activities under its license. Clause 35, further provisions on direction under Section 33, Bracket 3, Bracket D. The MA may, at the time of giving a direction under Section 33, Bracket 3D, attach to the direction any condition that the MA considers appropriate. Mr. Edmund Wong? Well, excuse me, Chairman, I'd like to go back to Clause 29. The revocation of license on winding up. That is, if the licensee is wound up, is deregistered, or struck off the company's register. If a company in Hong Kong is struck off the company's register, or is deregistered, or is wound up, then the license will automatically cease to be in effect. But what about a license is an overseas company? For overseas companies coming to Hong Kong to carry on business activities, what about these cases? Thank you, Mr. Edmund Wong. There are two scenarios. One, for non-bank issuers, they need to be physically present in Hong Kong. For bank issuers, banks could be overseas presence. So in this case, they don't necessarily need to have physical presence in Hong Kong. Any supplement? Well, yes, I do. My question is, Can overseas company come to Hong Kong to register as an enterprise in Hong Kong? That is my question. For an overseas AI, then it can apply for a license as an overseas AI. However, for a bank, not an AI, then it needs to be physically present in Hong Kong before one can apply.
I'm talking about two things. The body corporate can be overseas in Hong Kong. Well, whether it has a physical presence is another matter. It can be an overseas company and have a physical presence. But then a lot of Hong Kong companies don't have a physical presence in Hong Kong. Let's take a look at first whether a body corporate can be a non-Hong Kong company. Is that possible? Let me confirm this first. Chris? Thank you, Chair. Thank you, Mr. Wong, for your question. In Schedule 2, the minimum requirement is that there is a requirement on the company, and Section 3 sets out the types of companies which can apply for a license. The first is a company by the definition of the company's ordinance, and the second type is that authorized institution incorporated outside Hong Kong, a bank. According to the company's ordinance, this is the definition, and we are adopting the same definition here. The company must be incorporated in Hong Kong and registered in Hong Kong. Say if an overseas bank suspends its business in Hong Kong, and in accordance with the law, notifies the company's register that is about its cessation of business. Does it fall under Clause 29, revocation of license then? Chris, yes. But it doesn't say so here. Well, it sets out specific scenarios here: wound up, registered, or striking off. Cessation of business is not included. The physical presence is still there, but it doesn't operate in Hong Kong anymore. So does other sections in the ordinance cover it? Well, let's take out Schedule 4. As long as the licensee suspends its business, then that constitutes a ground for revocation of license. So let me take a look at the schedule first. I will come back. Ms. Carmen Khan. Thank you, Chair. I'd like to ask a question on Clause 32, temporary suspension of license. Does it tally with Schedule 4? If it is related to Schedule 4, what kind of mechanism will there be? You said that you would suspend a license for a period not exceeding 14 days. I think you would trigger panic there. You are temporarily suspending its license. So how does it work? How can you protect the holders during that period? I think you've moved too fast just now. How does the mechanism work? Well, first, a basic question is why would you build in such a mechanism? Thank you, Ms. Khan, for your question. Temporary suspension of license is different from revocation of license. So we will count on the conditions as set out in Schedule 4 before the MA exercises its power. Now, suspension of license 32(1). The period is not exceeding 14 days. So this is a short-term measure, and the MA believes that it has to take urgent actions. So it will temporarily suspend its license on an urgent basis, and the license is still valid. And it's different from license revocation. That means the licensee doesn't hold the license anymore. Both of them count on the scenarios as set out in Schedule 4. Carmen, any follow-up? You haven't answered my question. You are just reading the wordings from the provisions. But what we would like to find out is, how does this mechanism work? Maybe you have drawn reference from certain international incidents, certain laws from other jurisdictions. So in the case when conditions under Schedule 4 arise, you would trigger or invoke such a mechanism. And Schedule 4, you said that written representation will be allowed on the part of the licensee. And in 33 to 30, it says that the monetary authority believes that it's necessary in the interest of the holders for urgent actions to be taken. So we are empowering in the law for you to do so. What kind of urgent actions are you taking? So give me some scenarios as to why you need this kind of power, and how does it differ from Clause 33? 33 is also about suspension of license. And how does it differ from Clause 32, temporary suspension of license? Well, maybe you can give me a written reply in the interest of time. Give me some scenarios. And Chris, can you have a brief response and then give a written response later on? Thank you. First, we have taken reference from other laws. In the PS as VFO, we have a similar provisions. They have proved to be effective. And then why there are clauses 32 and 33? Well, we will look at the different severity of the scenarios. We will be mindful about the interest of the stablecoin holders. So the MA may sometimes evoke Clause 32 for suspending the license for 14 days, and for Clause 33, the suspension period is 6 months. And for revocation license, it's a permanent revocation. So they come with different effects. So Clause 32 is 14 days, and Clause 33 is 6 months, and then revocation for life or permanently. And then Ms. Johnny Ng referred to conditions in Schedule 4, say if the licensee adopts a business or engages in a practice that will affect the interest of Hong Kong's and international financial centers. Say in the case if there are rumors and the MA has to take certain actions, so maybe clause conditions 14 has to be invoked. I welcome that condition. Now, earlier we said that this stable coin is just a medium of exchange. It can be used for payment in transactions, trade settlement, supply chain, and used in the capital market, in the Web3 transactions, and so on. It is nothing more than a medium of exchange. If the business it supports is in a problem, and that if that business affects the interest of Hong Kong's and international financial centers, say if that business is involved in money laundering, does that mean that, well, in that kind of scenario, you would exercise the power given to you? Maybe you can provide us with some situations or scenarios to assure us that you are really welcome from the perspective of upholding the interest of the stablecoin holders. So can the administration provide us with a paper in detail on the scenarios that may arise under clauses 32 and 33? Well, there is difference between clauses 32 and 33 because we're talking about incidents with different degree of severity. So maybe we can go back and work out some scenarios for reference by members. Mr. M. Wong, I would like to follow up on the question of Clause 29. You talk about Schedule 4, say, if the company suspends its business, then its license is revoked. Okay, it's Schedule 4.4 bracket C, but it doesn't happen automatically. It just constitutes a reason or ground for the MA to suspend or revoke the license, rather. So in clause 29, it says wound up, registered, struck off. Maybe the physical presence is no longer here. So why didn't you include cessation of place of business? Why don't you include that expression in clause 29? Maybe you find it's too cumbersome, but that makes the clause complete. And that gives you a strong reason for revoking the license immediately. Well, if we include cessation of business in clause 29, that means that the revocation will be automatic. We don't prefer adopting a cut across the board approach. We would like to still have some flexibility. If that ground arises, that may be something that the MA will consider revoking the license. That won't happen automatically. Mr. Johnny Ng. I would like to follow up on Ms. Carmen Khan's question about suspension of license. Earlier, I raised a scenario. Say if this is an issuer issuing a large number of stable coins, and maybe it engages in an unscrupulous business practice, does it mean that the issuer engages in such practices or its intermediaries does so? Well, in that case, will his license be suspended or revoked? Well, would that be a sort of long-arm regulation whereby the intermediaries will also be regulated? Thank you, Mr. Ng, for your question. Your worry is that maybe the issuer issues stable coins, and somehow the people who acquire the stable coins are engaged in unscrupulous practices. Well, we will ensure that when the issuer engages in proper counterparties and intermediaries, they must partner with the trustworthy partners. The first thing is the issuer must monitor the situation of the market, because the issuer may be able to find out from the blockchain where the stable coins have gone to. And if irregularity is spotted, it can freeze the wallet, burn the token. This is something that the issuer can do. Now, if all these have been done, the unscrupulous practices cannot be stopped, then I think the issuer is not to be blamed. The second level or third level or the fourth level parties will be held responsible. In the bill, we said about the business practices engaged by the licensee. But if we're talking about the intermediaries further down the line, the licensee would not be held liable. So if the transactions, say, fall outside of Hong Kong, then that means that we would not do anything. What Ernest said, that the licensee must be able technically to prevent certain bad business practices. And if he doesn't do that properly, then he is to be blamed, but otherwise not to be blamed. So can you elaborate on that further? In the guidelines, we will give more details. Mr. Ng said that, well, there are technical solutions which are very mature through AI and so on. They would be able to monitor the transactions properly. But I must stress that we will not easily trigger such approaches. The first thing on our mind is to protect the users. And we would make sure that we would not make the users panic through our different means. And normally we would say that we would tell the user that we find that there is irregularity, then please make amends before we resort to other drastic measures.
Ms. Carmen Khan? Well, if members don't object, I will extend the meeting by 15 minutes. Thank you. Dr. Johnny Ng made a good point. On page 3593, well, let me play devil's advocate. Let me give you an example. While you're using stablecoin, and FRS may be used to do something illegal. In a world of stablecoins, regulation and supervision may be even easier. So let's focus on the business practice adopted by the license holders. If the stablecoins are used to affect the interests of Hong Kong as an international financial center, do we have any methods to counter such phenomena? It is possible the FRS issuers may not know this. For example, coins are used in transactions that are illegal, say human trafficking, drug trafficking, and so on. When this is known to the public, then this will affect the interests of Hong Kong as an international financial center. So when coins are used to the effect that the interests of Hong Kong as an international financial center are affected, so what will the Hong Kong MA do? In the world of blockchain, I won't say monitoring is easy, but it's actually easier comparatively. When these events become known to us, then we will handle them. In the world of blockchain, a lot of things are highly transparent. It is rare that we know nothing at all about something. We maintain close liaison with regulators, and we have information sharing. The purpose we want to achieve is to ensure suitable scenarios for the use of stablecoins. Then we conduct surveillance. We rely on collaboration among stablecoin issuers. We also exchange information with our counterparts to achieve this purpose. Thank you. So will the licensee not just engage in a business practice, but can you incorporate words to the effect that when the coins are used to affect the interests of Hong Kong as an international financial center, can you incorporate such words? In transactions of stablecoins, many of them are transactions in the virtual world. They take place even easier than FRS. So I'm afraid that the words engages in a business practice isn't sufficient. They aren't sufficient. We'll go back and think about it, but we'll have to strike a balance between this and the responsibilities of issuers. In Schedule 4, we mainly settle the grounds for the revocation of licenses. When coins are used by the downstream to engage in malpractices that may affect the interests of Hong Kong as an international financial center, do we need to pursue the issuers because of this? That is, the downstream of the issuers have done something illegal or affect the interests of Hong Kong as an international financial center. Well, then we'll have to think about this. somewhere in the provisions, probably you will have to add something. You need a method to handle these problems, not just one that targets the issuers. Just now, the MA mentioned money laundering. We have other pieces of legislation to handle matters in relation to money laundering. They may not be fiat currencies, but when it comes to money laundering relating to the FRS, we will invoke the relevant ordinances, and we will also refer the cases to other law enforcement agencies. So we need to strike a balance. Thank you. Well, probably you can draw reference from CAP 615, that is the AMLO. As well as legislation in relation to crime proceeds. In a marked up copy, you mentioned some ordinances, but I'm not sure whether relevant criminal legislation is involved as well. Well, I'd like to ask about Clause 32 and Clause 33, but you may provide a written response. When it comes to Clauses 32 and 33, how are you going to handle the stablecoins? Will you freeze them? Or will you still allow redemption of the stablecoins? Can you provide a written response? Well, in the interest of time, let's wrap up this meeting after going over Clause 35. Then we may start Division 3 at the next meeting. The next meeting is scheduled for 18th of March, Tuesday, from 10:45 to 12:45. Team, please take us through Clause 35. It provides for the further provisions on direction under Section 33(3)(d). The MA may, at the time of giving a direction under Section 33(3)(d), attach to the direction any condition that the MA considers appropriate. And according to B, the MA can amend or revoke the direction. The licensee will have to comply with subclause 2. All right, any more questions? No? Meeting adjourned. Thank you, members.